you as an experienced lawyer?
Yes, I could care less. I understand.
And finally, do you understand that if you are found guilty, you cannot claim on appeal that your lack of legal knowledge or skill constitutes a basis for a new trial?
Well,
In
no.
other words, you cannot claim that you received an
Ineffective. No, I normally go on to the trial court era. So if I go pro se and lose and have to appeal, it's definitely going to be on the trial court himself. So
do you understand the dangers and disadvantages of representing yourself?
yeah, I take the benefits over the danger.
Do you have any questions about the dangers?
I don't have not one question. I want to know where's my discovery.
Well,
And I got
we'll get to that. We'll get to that.
I got two motions that I want to deal with, and both of them motions to dismiss. One on one because the facial.
We've got to conclude this hearing.
Okay, come on, let's do it. Yeah, I can't wait till we get to this part. I thought we just did that.
No.
Oh, you got more questions?
You received and read a copy of the charges against you?
I have
Okay,
for what I've seen online.
All right, do you understand all the charges?
I mean, yeah. I mean, I guess understand. I mean, I don't accept them, but yeah.
During the time that you were represented by counsel in this case, did you discuss this case with them?
No, I don't even know them. I don't know nan one of their names or anything. So it's a good thing.
Are you aware of the potential penalties if you were found guilty of the whole first degree misdemeanor?
I don't care nothing about it. Oh, yes, I'm aware, but I don't care nothing about that.
So you understand that on first degree misdemeanors under state law, the maximum penalty is no more than a year in jail.
But what that's got to do with
12 months probation?
that's the charge. We haven't got to that yet. So why are you saying that and we only talking about pro
This
se?
is what I'm required to ask you. I didn't type up these questions.
It's almost like you already judged me or something.
The Florida Supreme Court dictates.
It doesn't matter if I'm going pro se or not. You ain't going to say that in front of the public defender. Oh, you facing it. That's if I cop out to a deal. I'm not willing to cop out nothing. We're going to trial.
Right, but if you decide not to go with a lawyer because you think that you're only looking at court costs.
I hope you don't think like that. I maintained 20 federal lawsuits by myself. Never had a lawyer in my life. And then one of the federal judges ever thought that I had some type of scapegoat. Everything I know I do is I'm responsible for at this point.
So do you understand that if you were to be found guilty?
Look, that's your second time saying that.
Yeah.
But go ahead.
Yeah.
No, go ahead. I see where you stuck at, but let's go. Yeah, I understand.
If potential
Yeah, let's-
implications of jail, a fine.
Yeah, let's just get past that. Yeah, because you said that twice already. And I already said I understand. I already said
You
that. That's
understand
twice.
that if you're not a United States citizen, if you result in
I want to know where you're going to ship this Negro here. Where can I go? You done took our land, Israel. Where you going to send me?
I just need to know that you understand.
You're not going to send me nowhere because you don't have a place to send me. You took my land over there in Israel.
Do you have any questions about the charges or the possible consequences and penalties?
You said that 3 times, and I said yes, sir.
And I'll tell you again for the third time. I didn't write
4th
these
time.
questions. I didn't write these questions.
All right, that's that 4th time though. But go ahead. I'm Mr. Gutman. Honor. Thank you, Gutman. Yeah. See, I said your name right. First time I ever pronounced it.
I need to ask you a few questions about yourself to determine if you're competent to make a knowing and intelligent waiver of counsel. How old are you, sir?
48.
You can read and write it.
Yeah,
You,
I think I can.
and you fully understand English, correct?
Yeah, I think I can.
How many years of school do you have?
Probably 1,
About high school?
but it don't matter though. You know that does not depict whether or not I can go pro se.
Education?
Probably 1st grade.
You didn't go to junior high?
Probably was kicked out or something. I don't know. I knew it was all kind of alternative schools, but somehow I got here.
Are you currently under the influence of any drugs or alcohol?
Not even. But can you test some of your bailiffs to see if they are?
Have you ever been diagnosed and treated for mental illness?
I think some years ago in 2016.
All right. For what? Can you expand?
No, I don't remember.
Are you currently being treated or under any medication?
Nope, I just take medication. I'm not going to get into that. I'm not going to get into my medical business with you.
Well, these are things I need to inquire.
Nothing, because I can't get into my medical situation with you. I have a right not to put my medical situation on your record.
Well, I have to make a determination.
Well, ask me the question. I said no.
I just asked that you're not answering.
I said no, and I didn't want to describe that.
Let's make the record clear. Are you currently under any medication that's for mental health treatment?
I said no.
Okay. Do you have any physical problem which would hinder your self-representation as the case?
No.
Speech impediment?
No, I don't have speech impediment. Sorry. No, I don't have a speech impediment, Your Honor. I'm very physically capable and strong.
So having been advised of your right to counsel, the advantages of having counsel, and the disadvantages and dangers of proceeding without counsel, the nature of charges, and the possible consequences in the event of conviction, are you certain that you do not want me to continue with you?
I wouldn't dare ask you for an attorney.
What's that?
I wouldn't dare do it. I'll belittle myself. They have already said they won't adopt the most dispositive motions in the world, so they're my enemy. They're just like the state.
If I allow you to represent yourself.
You don't have to allow. The Constitution says you must allow me. That's what the Constitution says.
I could have the assistant public defender act as standby counsel.
I don't want his help for nothing. Well, you know what?
He or she would be available to you if you have any questions in the course of these proceedings. Would you like standby counsel?
That'll be later. I have not made my decision and can't make it right now. Right now, I'm just on pretended per se. That's it. That's the only thing that's pretended to
Right now,
me
you don't want standby counsel.
at all.
Okay. So if you determine you want standby counsel, I would appoint standby.
I really appreciate it, Judge Gutman.
All right, so I've listened to your responses, and I find that you are making a knowing and intelligent and competent decision for self-representation.
Unequivocal.
I want to allow you to represent yourself.
Thank you very much.
I want to appoint you to public defender.
Yes, sir.
If at any time you want standby counsel.
Thank you so much. Thank you for that, Judge Gutman.
All right, so now, what I plan on doing is, because all these motions that you filed, until the public defender was not appointed, the state didn't consider it because they weren't adopted.
I understand.
Now they are. I have to give the state a chance on the motions to dismiss. They have to file, if they are, they don't have to, but they need to file written responses. Otherwise, what you've alleged is being admitted.
Right.
So, I'm not gonna hear the motions to dismiss today. I'm gonna give you another date, and I'm gonna give the state a deadline
Okay.
to file a response.
I understand that. If I'm in your courtroom, Judge Gutman, every now and then when I feel like I need to say something like any other attorney, I'm just gonna raise my hand like that real quietly. I'm not gonna I don't wanna butt in. I don't wanna have to force myself because everybody ignore me. But here's what I wanna say towards that. I understand that state got to prepare for my motions, but you have to understand, Your Honor, they have not given me discovery as of today.
Second, I'm gonna address that. I'm gonna give them a deadline.
That's dead wrong.
Well, here's the thing. You filing a demand for discovery is.
I asked the public defender, and he told me personally they didn't give it to him. This was just the other day, so it does not make no difference whether I'm not going pro se or not.
I'm gonna give them a deadline.
It's already passed, Your Honor.
Right, so under the rule, under 3.220.
15 days.
Right, if they don't do it,
They are
the
already get.
remedy is to file a motion to compel.
My attorney at the time already did it, and they still didn't obey it, and they didn't even obey your order.
Did you file a motion to compel, Mr. Hunt?
No, Your Honor, we filed our demand for discovery.
Okay, so I'm gonna treat your statement today as a motion to compel. And I'm gonna give them a deadline to get you.
Thank you.
Discovery.
And then we can go, I need that to go through my hearings myself. I got 2 motions to dismiss. And I have exhibits that I know the state wasn't gonna go get, but I have them, and they are inserted on the record. There are the video cameras on the outside exterior. Public records also suggest that Heartline have it, but since they're your agent and I'm suing,
All right, talk to me, sir, talk to me.
if I'm representing myself, I'm supposed to be able to talk to the parties too, right?
Right, but you're making legal arguments to the court now.
Okay, well, I'll just
So
tell you.
Let's take the motions to dismiss. I see that you filed a motion, 2 motions were filed on March 26th.
Yeah.
And more recently, there was an amended motion filed.
No, there's 2 separate motions to dismiss. One of them is on the fatally defective information, and the second one is where we at today with the Brady violation. I can't provide a defense without the hardline videos. I can't provide a defense without the hardline exterior videos they record. I can't provide a defense without the body cam video of each of these officers. I can't, because I'm also arguing resisting arrest. Even if I am guilty of the trespassing, the way they handled me and threw me in the car, I want every piece of video showing how they use excessive force to the point where the body cam fell off their chest as I'm in cuffs going headlong into a backseat of hard. I'm already in cuffs. So that excessive force gives me the right to resist. So I don't have my limbs breaking like you did George Floyd.
I understand the significance of the video.
And this is everywhere. It's a shame.
That's why I entered the order to preserve.
Yes, and I said as a black man, I'm rather going to face them having no videos at all. Because that's just what they do. And that's what I do. I sue after this. I already know they're not going to come up with the video. They're not that dumb.
All right, so on your two motions to dismiss, the C4 motion,
I have a C4 motion, Your Honor, and then I have a motion for Brady violation. As of today, because I demanded it, the attorneys demanded it, and that's that. I don't know about that compel stuff, but a demand is a compel.
so as to the C4 motions, those are the two motions you filed?
Yes, because they never put on the C4 motion. That's like the first one, not the recent one, the second one. The C4 motion, in the information, they haven't put anybody's name that actually had the authority to trespass me at all. That's right there is a violation of my due process because they haven't even showed that they had the authority to trespass me all in 1 second. And a trespass normally goes with a warning and then you leave. But when you getting trespassed at the same time as the warning, now we got issues. And the videos cover that. Because the videos don't show that. That means that the state is violating federal constitution. And then look at, they need to be over here where I'm at, in the defendant state. Because they're breaking laws.
Okay, so
Let's see if they don't break the law.
So I'm going to hear your motion to dismiss, your C4 motion. I'm going to hear them at 1:30 on the 22nd of May.